And Richie, I was driving and me car radio no eto City FM. Na I was listening to lawyer Bia na wo hwe ne accent say oye Nigerian lawyer ana ne boyfu a wo kasa dedenden, and I was like, hey, that be me relax na me nti asem na den na ekoso Nigerian lawyer ben ena ne boyfu say nti me relax ya me ti asem na me hu say, oh, say Gertrude Torkornoo lawyer. Gertrude Torkornoo nsɛm a wɔn de kɔ ECOWAS ECOWAS kɔ bobɔ nsɛm ne gu ye no ne lawyer ɛna trese ne buefu a ɔbɔ ECOWAS judges no echi na I'm say, oh wow. It's for people who don't know the story, I'll give you the brief and then yenim yema Gertrude Torkornoo, the former Chief Justice, His Excellency John Dramani Mahama Bambaye no eno receive petition say mamina ye nyama bia egu nejuma no enimtia na Ghana mran so trese obi a wo position bisa no oya ade na egu we dwuma enimtia wo se ye free ho. In His Excellency John Dramani Mahama share processes na se na omo ye Ghana mran nim se process bisa no enye easy inti yamfa nhye president ne nsa se president ni yi ni pakro no ye ka tre president ne se Ghana mran tre president ne se president no enkonkonhu enkrofo bi what ya say Council of States no munye BBC ni ewia yemfa nkonkomo obi ni set up committee na committee ne hwe nsem ni mu, so it went through all the legal processes, and at the end of the day the recommendation ekoma president ne say president ni yi ma me free ho as the Chief Justice. Na Ghana mran so tre say the recommendation ne ba president no opa on pew I was a recommendation no odiso and until president it the recommendation ne so, and from then yeni na yehu senia ye maame I will take you know. In fact ewo Ghana nkwano the number of suits are wa file based on the removal no I think say bedu be 10 say what the ECOWAS the ne kan ho aye say bedu be 10 inti say Ghana has say court ebobo ne nsemegu no eno call ECOWAS eno ko raise issues so me menya lawyer ba me tena platform we so every day ne nsemo de ko to ECOWAS no e ma me tre mo say nsemo de akoye de no ko ne nyame anim ni enkoye na surprisingly and not surprisingly no just around last week ena ECOWAS ruling no ebae asemo a mekan ye issues are raising ye ne nsemo a mekan no those were the same things ECOWAS judges no erase. And the maame no ne lawyer because oko ECOWAS no okofa one of the best lawyers in Nigeria. In fact embra oko ECOWAS okofa sa lawyer yi no enkrofo ka say based on the lawyer maami akwa fenti obe wini case no ECOWAS but metena ha ka trem say he Ghana we are a sovereign nation enti say yenye constitution it take effect na Supreme Court rule say president na dia wo ye no e right mo pese mo trem say ECOWAS ebe she Ghana say mayendi ye constitution echiana, and that is exactly one of the rulings at ECOWAS the buy, you know. But ye mami ne lawyer ne buefu ena waba bonten kasa a trese ECOWAS judges no senya waso mumu ewo trese online and yasem get. We are going to read and then you understand his argument. And then your first time or have Mr. subscribe it, click the notification bell on so oya ne sa latest news bia ba on sa ebekan ebusuanfo unim say problem bia wo face bia no health issue bia no there is a natural remedy for it. Say o high cholesterol or natural remedy garlic capsules every day for garlic capsules. Say o high BP every day for moringa tea. Onipe bia wo didi wie na opese aduane ne digest ya for green tea. Oye bema na opese moja die fusani ye na sebe on pese dachi obema ebewu a mesre for beetroot capsules. Oye bema na opese o obo edwuma ye e wo mpemu a ye free herbal products be maca root we ni na ye natural herbal products free Nature Heals Herbal Shop na o needs bia no katre no non supply amount 059-800-3891 na ye ni na no yen hwe yon so ye now yen ko story ne so o say Torkornoo's lawyer Femi Falana tears into ECOWAS court ruling. Also, Nigerian lawyer and senior advocate of Nigeria, son, Femi Falana, who represented former Chief Justice Gertrude Torkornoo before the ECOWAS court, has criticized the court's decision to dismiss her human rights case. in an exclusive interview with Ghana Web's Mandy Ajimai. And there is something also happening. Utumi Hune say, if there's one thing about Gertrude Torkornoo, is the fact that she's really making use. I don't know whether it's the, okay, who study MPP the strategy most of our lawyers no in so use no nipa ba ko no so tie use that strategy nipa attaching they are able to use the media, the social, like what you say, they know how to use the media. It's a same where they will come on the media and then they will speak in a certain light. Ebema public no, as a they will get some public sympathy. But unfortunately for them, Ghana for experience Gertrude Torkornoo being a chief justice. Anything ama Gertrude Torkornoo same way abano. Ghana for bebre na be support because ye ni na ye hu rulings bi a wo man ya ordinary Ghanaian MPP ni krat na se hu said that be mami ruling ya who made here na looky too biased. Normally no people are supposed to cry for her, but no single Ghanaian MPP for no single neutral Ghanaian is even crying for her. Sa social media na mobekwa enkonko siaga. Anyway, also in an exclusive interview with Ghana Web's Mandy Ajimai on Thursday, July 2nd, 2026, Falana described the judgment as a departure from the court's established legal principles, arguing that it failed to apply the same standards it had used in similar cases. According to him, Torkornoo had asked the court to grant relief over alleged violations of her right to a fair hearing, work, information, and dignity. Also, the court considered the application, but unfortunately departed from its previous decisions in similar cases. So, if the court rules on a case and then they depart, right? It is a crime, eh? That's what the Gertrude Torkornoo's way is telling us. It is a crime. You know yet to know my way any who the 2020 election petition, when it was time for Jean Mensah to be cross-examined, how they shielded Jean Mensah, and that one, they departed from precedence. You know Emra MPP election petition in 2012, right? Was it 2012, 2016? I stand to be corrected, 2016. We saw how Afarijan was grilled during cross-examination. That was the standard. That was the precedence. Gertrude Torkornoo was part of the panel. Embra na Jean Mensah ba. Womo katre sa time. Chachuchi kata as if he knew. Se no mbeye sa. Omo tro. Chachuchi kata throw questions be ma Gertrude Torkornoo. Message Gertrude Torkornoo, sorry. Jean Mensah. Say on answer. Gertrude Torkornoo was part of the panel. Mokatre Chachuchi kata said, it will be time for you to cross-examine her. Inti edua no wa answer questions no. Ena Chachuchi kata tiase. Edru say yebeye cross-examination no. Yesi ye mane nye. Chachuchi kata bekai mo say mwana mo tre me mbra na me si on answer questions initially a case ni shase no mo tre me say cross-examination metumia amana answer. And they do cross-examination na mo se mo mpene. Adai. Ye mo ye nya fair. They departed. But it was right. But then ECOWAS no. You see similar cases about ECOWAS. ECOWAS ruling na wamuma ye no. Gertrude Torkornoo die nkwa no. Omo amasa ruling nti enye fair. Oh, wow, that's nice. Oh, that's nice. That's interesting. You know the number of cases that Gertrude Torkornoo natina so Ghana are ruling no. Or departing here from the precedents. Do you know? And then as she's experiencing it, yate. Also, according to him, Torkornoo had asked the court to grant relief over alleged violations of her right to a fair hearing, work, information, and dignity. Also, the court considered the application, but unfortunately departed from its previous decisions in similar cases, he said. Also, the seasoned lawyer further argued that the court wrongly declined to examine the reasons relied upon for Torkornoo's removal, claiming that doing so would amount to interfering in Ghana's domestic affairs. Exactly as I told you. When the case came, Mekatra will say, courts never cast a dabi. Omun to me, Congo Tregan at the Omunye. Ain't it and I get to talk on no lawyer, someone walk and say, now can this point say courts never cast a diano? Sir, more cancer move to me Tregan at the Omunye, and the entire more cassa, as someone get to talk on the lawyer air canon. He maintained that in earlier cases involving judges from Nigeria, the Gambia, and Libya, the ECOWAS courts examined the grounds for their removal and assessed whether the disciplinary processes complied with due process. The court claimed that it could not look at the reasons advanced for sacking her because that would amount to interfering in the domestic affairs of Ghana. But we are saying that in other cases, including the cases of Nigeria, Justice Wowo, the Gambia, Justice Jane, and Liberia, the ECOWAS court examined the reasons for sacking these judges and came to conclusion that the committees that investigated the judges were not properly constituted, in the sense that some of the members did not sit, including on the day the decisions recommended their removal were taken. It was say ABC or Nigeria omuyi judge bi. ABC wa Gambia omuyi judge bi. ABC wa Liberia omuyi judge bi. Omuko ECOWAS na ECOWAS Emma ruling say indeed decision ana de ye ye judges no. Enkaye. But you know Gambia for omu processes are omu de be judge. E different from Ghana. Ena o hwe Justice Torkornoo lawyer nsemu a wokana. Obeso atrese indeed ECOWAS etiasie masankrofo no because na ye say even the members, some of the members no omantenase. But Ghana has said that's not the case. The processor a course who Ghana has no obienim. Say I mean it was obien ye. Or say in the case of Ghana, Justice Torkornoo's matter, the ECOWAS court said these are the reasons for her removal. We can't go into them. The court simply said, if we go into these reasons, we will be interfering in the domestic affair of Ghana, he stated. Falana argued that some of the allegations against Torkornoo did not constitute valid grounds for her removal. According to him, the deployment of judicial staff was within the powers of a Chief Justice. Traveling with her husband was permitted under Ghanaian law and had been cleared by the Auditor General, while recommendations for appointments to the Supreme Court could not be held against her because the appointments were ultimately made by the appointing authority. It's a Nigerian lawyer na asema what can I say? Gertrude Torkornoo ya yeyi no. Ghana for ya yeyi na enye mbra. But a Nigerian lawyer but no no betre ye mbra. Say ya ye digital so yi na enye mbra. Because you see Gertrude Torkornoo oni ni kunu akwa tukwan Ghana mbra tre say ya ne oni ukunu tukwan aboni nim. You see, and it's one of the things I say oversimplification of the issues. Obianka say Gertrude Torkornoo mo ni kunu tukwan Ghana mbra tre say ubetumi ni ukunu etukwan. But enya aban no memfa unsa nkonko boga na sikemu emfa nkonko tukwan. And the current Chief Justice say Ghana World Cup wakobi akwa akohwe we tukwan. But odiono ankasa ne pocket money ene ekoye. Inti ene na enya problem. Allegation ayedem bog Gertrude Torkornoo no ene say oni ne kunu ene ne mba etu kwan no. Eye Ghana sika na nke ni kwan so wo ye ne saa. Per diem wode ma wo mu eni kwan so ye ne saa. Inti ukokot na ukoka se Ghana mratre so betumi ni kunu etu kwan. Inti die ntia no ni kunu etu kwan ya problem da abi. Obi anka se ontumi mfa ni kunu etu kwan. Odi ni kunu tu kwan e na nke ye ono ani sika ana odi ni kunu sika eni tu kwan na nka problem ni ho. But taxpayers money and allegedly no odi tu kwan. Inti that is where the problem is coming from. So oversimplification of the issues. It will not help anyone. Falana also challenged the composition of the committee that investigated the former Chief Justice. He argued that 2 Supreme Court justices who served on the committee had previously sat with Torkornoo on cases that later formed part of the allegations against her, making them judges in their own course. And you see, this particular argument will tell you say Gertrude Torkornoo knows herself. And it will tell you that probably she knows. Say ono ane judges ni bi kra no. Or ye nyame bi a wo momfo aso. Because as someone can say some of the issues, and I think say issue are all raised at this point. I don't know. I mean, on say the Daniel Ofori case war, and then there was also a lawyer Bia one also accusing Gertrude Torkornoo so ye nyama bi, right? But what share issues now Gertrude Torkornoo all raising now. Also 2 judges be at na case be so. Sa case ne kan. Sa ensem na aba mu enim no emu. Judges no what asem. Inti at that point. Say woni wo colleagues ye adwuma. Na oni omo udi asempa. Na wo colleagues no oni omo e the same page. Do you think say asemu a wankasa oni omo atena so ye say ehho aba asem na ye say ye pe obi aka ma wo na sa wo colleagues no e na e betena sa case ni so a don't you think say udi asempa na nka colleagues no be twitwaje? And so the fact that you are also saying say me ne nkrofo two way na tena case we so na case we ho asem na aba e ka ho ayese ye mfen yime na nkrofo e de misusu say because omo tena case ni so nti no omo be pene ama ye yime dia na tre say wa na wonim say case na otena so na nkrofo ne tena so no we ndi asem de and now wonim say you were opposing those people because only omo ni na tena asem amos decide say okay case we ya be say ne yenko no say ne yenko and na only omo ni na adwen eye benkroa na kende asem ya be omokra na betwitwaje wo na ka okra we ni beje na woni nkrofo ye adwuma na nkrofo na oni omu ye adwuma no oni omu a na take decision bi na later asem aba ye say nkrofo ya oni omu take decision no omu no mu ye judges omu tena wa asem no so say okra we ni beje because at the end of the day enya me kwa na me koko take decision me ni omu na take ye nti on betwitwaje me. It's the fact that you are even using it as an excuse today. Some of us, it will tell us, say, any emra na oni omotena case ni so no. Na wonim say nsem bia wudi no, ebia na enko ye. That will for say wo ho because that time now ye Chief Justice. All right? Also on the composition of the committee, we did say that the 2 justices on the committee are colleagues of hers on the Supreme Court and sat on the same cases with her, which were later used against her. In other words, these judges were sitting as judges in their own cause. They violated the principle of nemo judex in causa sua, he argued. He further criticized the court's finding that President John Dramani Mahama was not required to provide reasons before determining that a prima facie case existed against Torkornoo. And that is Ghana's constitution. Ghana's constitution is not telling anyone. Say president no empha reasons for a prima facie. But Falana said his legal team relied on the Ghana Supreme Court's decision in the Utah Dairy and Tiger IPI case, which held that decisions taken under Article 146 of the Constitution are quasi-judicial and therefore require reasons. On the issue of fair hearing, Falana said the Piaman committee set up to probe the petitions against Torkornoo completed its work on August 25th, 2025 and adjourned proceedings to September 15th, 2025 for the adoption of written addresses. However, he alleged that members of the committee submitted their reports to the president on September 1st, 2025 before the scheduled hearing. Also, our allegation, which was not disputed, is that the committee concluded its work on August 25th, 2025. On September 1st, 2025, the Chief Justice saw the committee members presenting the reports to the president, so it is a violation of fair hearing, he maintained. Falana also questioned the committee's handling of multiple petitions against Torkornoo, arguing that it had no authority to limit its work to only one petition without presidential approval. He further argued that 3 non-judicial members of the committee failed to take the required oath before beginning their work, which he said breached constitutional requirements and due process. On the issue of access to the committee's reports, Falana rejected the court's finding that Torkornoo's right to information had not been violated because she did not formally request the reports. He said the legal team tendered a video in court in which a senior official at the presidency allegedly stated that the government had decided not to release the reports. Under Section 23 of the Constitution of Ghana, any judicial or administrative panel that makes a determination affecting your interest must provide you with a copy of the report because you may want to challenge it in court of law. In this case, the court said, sorry, there's no evidence that she applied for the report. She didn't have to apply for the report because we tendered a videotape of a top official at the presidency who said, we are not going to release the report. The government has decided not to release the report. So how can you now say that the respondent, the government of Ghana, had not violated her rights to information? And you see, this, I have saying so, you know, there is some tactics. If the government is saying that they are not going to release the reports, the government is speaking to Ghanaians, said they are not going to release the report to Ghanaians. It does not mean that Gertrude Torkornoo our part and a party of the whole case. No, the report is not going to go to her. And so, if you tender a top presidential official, as Gertrude Torkornoo's lawyer is saying in court, name some court. Now, because we government a releasing reports, said they are not going to release it to Gertrude Torkornoo. You know, government did not release. And Brad Gertrude Torkornoo Troye Emma Aban say in some way raise etiano no Aban money no Aban tro command right Aban money who allegation no, but Aban did not release it to Ghana for after Gertrude Torkornoo responded e could do no any leak here, right? So government did not release the reports to Ghanaians, but it does not mean say because they will not release it to Ghanaians, they are not going to release it to Gertrude Torkornoo. Two different things. Two different things at all. So if the lawyer na court na or can say where I don't understand where the argument is. It's not holding for me. And I've told you the reason why a government MPSA obey release a report no to Ghana for NSA. You see a indictment. A encrofor ena omo hu boni ewa judge our Supreme Court judge and our Chief Justice. Chief Justice na judges for na penny, justice for na president. Say on my penny ni Ghana, Vice President in Ghana. In fact, so my penny ni Ghana na Vice President in Ghana. Chief Justice ni na your friend saying Speaker of Parliament in Ghana. Chief Justice no than president. It is a president, His Excellency John Dramani Mahama Tukwan. Na ye mame Professor Jenna no Pokwajiman Tukwan. Na Abambagwinsu Tukwan. The Chief Justice is the President of Ghana. Inti se wakwa ko dibone na ye ba bebiemu etre Ghana for. People will lose trust in the justice system. And in a country biano, your last defense is your justice system. Once people start losing trust in your justice system, people take matters into their own hands. And you become a banana republic. So Crawford decided to move taking matters into their own hand. Only obinya semwa. On yase wako reporting wo police impo or fail to know their bond in we kuno. Chaos will be all over the place because people will decide say omo nombe take matters into their hand. Omo ye the last defense line for justice. And you might be wrong on a certain issue. A judge nebeka. But because you feel say wa sem ye deninti, ubekwa ko di obi bone. So based on that thinking ninti no, Aban say bone a ya kan fa maami hu no, ye ma Ghana fo hu because Ghana fo kokko hu a. Omo abembe bu e wa justice system ni mu. And it has a long-term effect on this country, on the peace, the national security of this country. Inti Ghana for the yen release reports ne ma Ghana for ema wo mu hu in ade amaame ne ye ya ema yedie yi no. But maame ne de say you no asem inti onu de be release atre no. Inti se maame lawyer ECOWAS court no koka say enle Ghana for penyin bia wo free president ho tre say on release report no ne nso tre say omo so mu release maame na. You two different things. Maame ne de ye ni oni anim say you release man no. E no bisa yanke de be ma no. But Ghana for ni release momo. So two different things. It was say Falana concluded that Several aspects of the judgment represented a total departure from settled principles of law and the respondents of the ECOWAS courts. And you know, Osha, no, na ne buefu pa Gertrude Torkornoo lawyer, ne buefu anenya asem ketwa, but the ruling is the ruling. Adia ba kwa wakan ya eye mesre ne se on se ECOWAS court no omuni appeal, omuni appellate court. ECOWAS okosa level na they don't have an appealing chamber, an appeals chamber. Tasemba kwa okaya eye mesre ne se Gertrude Torkornoo case inti no ECOWAS for omon set up an appeals chamber. No mo konkoye appeal. And I'm say, hey, na Gertrude Torkornoo dey the whole world no na the who here found. ECOWAS in the appeals chamber. No unti ECOWAS set up appeals chamber. That's quite interesting. It's what your comment box ni mo me da say.